Well, thank you so much, and thanks for having me here. Now, just to say that, coming from government side, I don't want to say I'm apologizing, but I'm saying that I can feel where we are and the gaps in this industry. I mean, coming here and looking at what we have at this fairground is mind-blowing. And it's like, so where have I been all this while? I never knew that Nigeria had such a huge, amazing leather industry. So that's a learning curve for me. And I can assure you that a lot of people out there don't know what we have in this industry. It's huge. Having said that, looking at the law, and we'll get to that in the course of the conversation, it does appear that we have not customized our laws to take care of our needs in these industries. You know, Nigeria will usually rely on the law as it is globally, global templates, and like my colleague will share later, we're still behind in some of the laws. I mean, our Trademarks Act, for instance, is a 1965 statute. Our Patent and Designs Law is a 1970 statute. Fortunately, the copyright law is in 1988, amended last in 1999 statute, so that's a bit better. But even at that, we're far behind. So there are gaps in the laws. Beyond that, there are gaps in terms of the institutional infusion of policies. So for me, this is a place to begin to take in suggestions, and those in the industry should be able to tell us where those gaps are. And I'm hoping that by the time we finish this conversation, we'll have a plan of action. So we don't come next year again to talk about those gaps. We must have deliverables. And I can assure you that this panel will certainly work together to have those gaps filled and those deliverables, put forward so that this industry can benefit from the legal system like many other countries have done.
Absolutely. Well, I'd like you both to feel free to jump in on the conversation, but from a lawyer standpoint, what are your thoughts, Chinyere?
Hello? Okay. Hello, everybody. Okay, first and foremost, is everybody in the room a manufacturer? If you're not a manufacturer, just give me, I want to get a sense of who we're speaking to. If you're not a manufacturer of leather goods, just indicate by raising your hand, please. If you're not. I mean, not that many. So what do you do? Sorry. IP lawyer, okay. Lawyer. So we have a couple. Anybody else a lawyer here? Okay, a lawyer there. And anybody else that is not a manufacturer of leather goods, what do you do? Yes. Model. Hi. Okay, so first and foremost, thank you for having me. I also was blown away when I got in here and saw the number of locally manufactured leather products there are. I mean, I didn't have an idea that this really is something that is a niche in itself and something worthy of bringing to the limelight. And so I really, really appreciate the initiators of this fair. I know it started a couple of years ago, isn't it? Yes. So that's really laudable. Now, for me, when I look at the topic, which is creativity and the law, how to protect your brand, I think that from a lawyer's perspective, the most viable area of the law that you could use to protect your creativity would be intellectual property law. And so most of us on this panel, I would say, are intellectual property experts, and that's the conversation I would like to have. I would like everybody here to leave with an understanding of what really is intellectual property. When I create something, how can I protect it? How do I ensure that this thing I have used my intellect, my creativity, my artistic endeavor to create, and it's something I'm offering for sale to the public. How do I ensure that no one else copies it, nobody copies it and sells it, no one with more money than me can go and produce it, and so on and so forth, so that I actually reap the benefit of that creativity? That's the conversation I would like to have today. And so I came here prepared to discuss that, to take you through the types of intellectual property. And then at the end of the day, I would like us to now narrow it down to the industry where you are all operating, which is the leather industry. Which IP laws would best be suited? And just like Mr. Sen said, unfortunately, a lot of the laws in Nigeria are not up to date. So there are gaps in the law. But what do we have, and how far can we apply them? To what extent are they sufficient, and what do we need to change them? And hopefully at the end of the day, we can pinpoint those gaps and now create a working group that can look into them specifically for your industry and ensure that this wonderful asset that Nigeria has as a nation, that it doesn't go to waste.
Absolutely, and Chinyere has a slide she's going to take everyone through as well, just to, teach us a few things. But Annie, you sort of find a way you meet lots of entrepreneurs who are also facing some of the issues with regards protecting your brand. You do webinars and stuff like that. So what are the challenges specifically that you find that people have?
Okay, so, hello? So from the intellectual property perspective, leather works can be protected through several aspects, including copyright laws, trademark laws, industrial laws, industrial design laws, and patent laws. So before this protection can be applied, there are certain components that have to be identified in the works, basically. And the things that are to be considered are the reputation. The reputation is the style, the origin, the quality of the work. So that is the reputation. Then the external appearance. The external appearance is the shape and the design. Then the creative process. That is the basic know-how, and that's catered for by the patent laws and having a trade secret, basically. So a lot of designers, when I interact with designers and all, usually they have issues protecting their work because they don't have a protection strategy. They don't have strategies on how they can protect their work. And it's something that even everybody here, manufacturers and all, it's essential that you all, from the creative process to the final sales, you all have protection strategies.
Okay, all right, so just so you know, this is not about me, this is about you. I'm going to start to take the microphone into the audience so that you can ask questions. So ask questions, you already know what they do, you know what they're talking about and what they're great at. So we've got our first question coming from this side.
I'm World Rapperman. Unfortunately, I'm not a lawyer. I'm a rumpreneur. I'm a charity runner. And I came here because of my own issue. I started something many years ago, and I'm about losing it, so I want to know.
Sit down. You can sit down.
Oh, I can sit
Yes,
down?
yes.
How do I protect my brand? I'm the only man in the world that runs marathon and long-distance race dressed like this. In 2003, I registered the longest rapper in the world with the Guinness World Record, but they refused to publish it. And I'm getting older. I'm not going to be running for all my life. If tomorrow one young man, I already have a young man running with me now. If tomorrow he begins to make money from this, what I started, how am I going to protect myself? And I am, to the government side, Mr. Asen, nice to meet you in person. 8 years ago, I was in one of your offices. And what I noticed, let's be frank, sorry if I'm being blunt, government officials frustrate creative people. They don't want to hear or see you. They will frustrate you with bureaucracy. They do a lot, and we become enemies. So I asked, when I was young, I read a lot of magazines, and I know that if you post a letter in Europe or in America to yourself with a stamp, it becomes more like a patent thing to you. If I'm right, you can prove that in the court of law. If there's a date on that stamp, So and I asked some questions. They said, oh, no, you cannot, this cannot be done in Nigeria. You cannot register this. What is rapper? And I said, I'm the only man in the world that runs like this. I run long distance race dressed like this. So how can I protect it? And nobody's telling me anything. So I don't know if I'll get help here today. I actually came to visit a friend's stand. But I said, okay, if they won't drive me out of the class, I'll come inside.
I want to understand, have you finished, sir?
Yes.
Okay. When you say you run like this, I don't know what you mean. Can you explain?
I run marathon long distance race dressed like this. I've
Dressed-
run with a rapper.
Okay.
I have the world record of the longest rapper, 37 yards long, 5 kg weight.
Okay.
I've run like this from Lagos to Abuja, 22 days.
So it's the outfits that you're wearing to run that you are thinking you should have some protection
Not thinking,
over?
I want to. I've been doing this for 10 years.
Because you've decided that instead of wearing trousers or a tracksuit or the normal sports wear, you will wear a wrapper.
I want to be different. I'm promoting culture, I'm promoting tourism.
You want to wear the wrapper to run the race.
Yeah.
And it's unique to you.
Not to me, not to the world, because...
No, it's unique to you. It's something you originated.
Yes.
Okay. Is that protectable?
I think so. Like from the trademark perspective, like protecting the reputation, like it can protect if you have a brand name, for instance, like you have a name, a brand name, you can actually protect your brand name. And from the industrial design law perspective, like I don't know if you have unique wrappers or something.
No, what I do, I just travel anywhere in Nigeria, anywhere where the tie wrapper, I promote that.
Okay, so if the wrapper is
it's a
not
business idea then.
Okay. Let me see. Well, maybe because you mentioned your experience with the Nigerian Copyright Commission, I should jump in here. First, I thank you for being so frank. And I will say it here that as a government office, you are responsible to the citizens. And you must answer their questions. So I'm sorry if that happened 5, 6 years ago. I'm sorry. In fact, I would want you to please come back. You could visit our office in Lagos here, and I'll get someone there to sit with you and have a discussion with you on whatever could be the issues. The reason is that, I mean, you are passionate about something. You heard us, whispering to see if we could find somewhere in the law to protect this. Now, you have an idea that you are promoting. We must find a way of using all the available legal mechanisms to add value to what you're doing. For instance, first, let's know that everything is not always about exclusivity. So you don't always protect to exclude people. There are times you protect or you seek acknowledgement so as to gain the value. So for instance, now you have your name as a world rapper man. That is something that you could build on that reputation, and rapper man becomes an asset. It could become an asset that textile companies will come and say, look, let us use rapper man for our textiles. So you won't say, no, don't use it. I want exclusivity, because that's no money. So you could tell them, okay, you use rapper man, but you pay a fee. Then you could endorse some rappers and say, this rapper is endorsed by the world rapper man. And I tell you, if you make ₦1 from every yard of rappers sold in Nigeria, you'll be a happier man than wanting exclusivity. So the model you adopt must be the one that will work for what you seek. Having said that, you have a lot you have put in. We can begin to build the rapper man brand and bring value to you. But you must now run that as a business. It's not just sentiments. Whether Guinness Book comes or not, that's beside the point. But if they come, it's good. It means you now have global recognition. But you must build on that. And there must be a reason why someone will come to you and say, rapper man, please endorse this rapper. So there are business models we can now bring in that may not be exclusive IP protection, but you end up having value for what you're doing. So if that is okay by you, then you're coming here this afternoon must have been worth it.
Absolutely, fantastic.
And I promise you, before I leave here, we'll exchange numbers, and I promise that the Lagos office will attend to you.
I think that deserves a round of applause. Fantastic. Thank you very much. We've got the mic here, so who else would like to ask a question?
I just wanted to add, just because I believe that most people here don't understand, or maybe I'm wrong, so forgive me, but intellectual property, when you talk about intellectual property, it really is just like you have your landed property that you own, a physical item that you own, your handbag, your shoes, this book can belong to you, your phone. It's just like property of the mind. So when you say intellectual property, it means some idea or some product or something that you have used your human intellect to create. And then when you've created it, you can now multiply it in such a way that it brings you a monetary benefit. Now, in the broadest of terms, intellectual property has two broad headings. There's copyright on the one hand, which most people know. And that's where you have your artists, your musicians, broadcasting, artistic works, literary works, that is books, magazines, novels, you have paintings. So copyright is very broad. You have your musicians, you have your actors and actresses, then you have radio. All that is under copyright. And copyright is actually seen as a natural right. I will let Mr. Essien has written what I call the only book on copyright in Nigeria. When you read his profile, you said he wrote the act, but it wasn't the act. It's the only textbook worthy of note on copyright in Nigeria was written by him before he even became the DG of the Copyright Commission. So I think he deserves a round of applause for that. That's the book we still bring out time and time again. So I will leave him to talk about copyright. Then the other side of intellectual property is called industrial property. And that's where you have your trademarks, your patents, and your designs. So designs, you can have textile designs, then you can have industrial designs. So trademarks, who knows what a trademark is here? Anybody? No lawyer should answer. Okay, so a trademark is a source identifier. It is the name you put on your goods or on a service that you're offering to the public. So for instance, this bottle of water is named Eva. It's a physical product that you can see, and I put my name on, it has a name on it called Eva Water. If another person were to make water and call it Eva, if this Eva is registered at the Nigerian Trademark Office, they can bring a case against the person. It's not only for water. Trademarks are on any item that you think about in this world that is sold to the public, because if you don't put a name on a product, how do you differentiate it from that of another person? So as you're producing your leather goods, your shoes, your bags, your belts, and so what, furniture and all that, most of you have names that you call it. But a trademark is different from a business name. A business name is the one you register at the CAC, that is Corporate Affairs Commission, which gives you makes you become a legal entity before the law, and you can sue and be sued. What we're saying is the trademark protection is the name you put on your product to sell it. It can be a physical good, so the names of banks, it can be a service, the names of schools, the names of the phone. And I brought some things here to actually share with you so we can be interactive, what a trademark really is. It's important that you understand that the trademark is different from the other one I mentioned, which is a design. So a design is a 2 or 3 dimensional article. So the name of this is Eva, but this bottle has a shape. Abi? The shape of the bottle is also protectable as in intellectual property because somebody actually drew this, conceived it in their mind, put it down in paper, drew it, used the mold, gave it to the people that made it into this bottle. So most waters you find, all of them have different bottle designs. They may all be made of the same material, this plastic or whatever it is, but they're all different. So again, that's a second type of intellectual property, the design. So the bags that we make, that we're all carrying, the Femi handbags and all the other brands here, they all have different shapes, which under the Nigerian law can be protectable as designs. Now, what intellectual property law does, basically, is a right that excludes other people from using it, like Mr. Essien mentioned, although it's not always about exclusion. But if you register it with the Nigerian Intellectual Property Office in Abuja, then you have a standing under the law that can say, okay, I protected it, how can the law cover me? There are other discussions that we'll have today that show that there are loopholes in the law. That is, even though you have a design, so many people are copying the shape of your bag. You understand? What can you do? We'll have that discussion today. Then the third type of industrial property, I'm sorry, I'm hugging the mic, is patents. So patents is, if for example, this wasn't water, because I guess water is just H2O, but if it was like a Coca-Cola drink inside here, there's a particular formula inside the Coke that makes it taste the way it does. Or the formula inside a Panadol, paracetamol, or Voltaren cream, or any medicine you can think of. Or the engine inside the telephone that we have here. These are called patents. They're actually things that somebody actually did all the research and whatever and came out with this idea. And at the point you're registering the patent, it has to be new. That is, it has to be what they call not something that is already in existence. You understand? It has to be completely new. So the machines you use to sew your bags or your chairs and all that, the engines inside are patented. Now, another thing you should know about intellectual property, especially the industrial property part, is that it has a lifespan. So you register it for a certain number of years, and then you have to either renew it, or at some point, if, for example, patents, there's something called compulsory license. If it's like a drug to cure HIV, for example, the world will come out and say, it's something that can benefit everybody in the world. Therefore, one person shouldn't own it alone. Therefore, you must give licenses to different people to use it because it's something that can help the whole of humanity, in which case, one person can't hog the formula to themselves. You know, so I'm just trying to give a general overview of what intellectual property is. It's very wide, it's very interesting, and it's the protection that you will need as manufacturers in the leather industry.
Absolutely.
I hope I'm making sense.
Yes, and it was so important to break it down like that. A round of applause. It was so important. It's important to break it down like that because we assume people know, and people get taken advantage of because we don't know. So it's important to break it down like that. So any more questions? Mike. Okay, we've got someone here.
Hi, my name.
Is it on? Okay.
Hi.
The mic, you can take mine. Thank you. All right, what's your name?
Hi, good afternoon. My name is Teresa Itukudo. So my question is for Annie. You said something earlier. My question goes, what role does patent law play in the fashion industry?
Well, for patent, it's actually really complicated in a sense, because usually what can be applied or what is usually effective, trademark laws and industrial design laws, like she mentioned. But for patents, it depends. If you're producing something that has inventive process, right? An invention, for instance, right? Let me think about something, like an outfit that has technology, for instance. People are already doing stuff like that, so they have patents for that. Maybe someday we'll get to that point in Nigeria, but like, that's the level, yeah.
one of those shows they do, these American, not a show, I don't know, all these stars were attending one of those their events. I can't remember, but it was either Lady Gaga or something, wore a dress that as she's walking, the dress was changing color. It was the Oscars or something, one of those their things. Which one was it? Aha, thank you, dear. Yes, it was the Met Gala. Yes. So someone wore a dress that as the person was walking, it started out as pink, then it changed to another color, they changed to another color. Do you understand? And finally, now maybe shown. So that is inventive, and that is fashion. You understand? So, I mean, that just goes to her point.
Sorry, just 2 quick points here. I mean, one, to address what you just said. And, you know, there's some shirts, if you wear, the stretch. Okay? Yeah, the stretch. I mean, for a cotton material to stretch, something must have gone in there. Now, you have a choice to make, either to go by way of patent or to make a secret. So in this business, there are times you may need to use trade secrets. For instance, how do you make your leather such that even when you soak it in water, it comes out and nothing happens to it? You know, you soak in water, it doesn't smell, nothing. So people just, look, how do you make your own leather? Mine just keeps, say, well, I miss Abi. You may want to keep that a secret. So there are times you keep the secrets, how you manufacture, the process you use, how you achieve some results will be kept secret. But the danger in trade secrets is that once someone is able to break the lock, it's gone. So if it's something that you cannot really keep secret, you're probably better off having a patent. But taking the risk that after 20 years, the patent will expire. Then everyone will be free to latch on. But there's always a way out. Now, before the 20 years, what you can then do is to use the trademark system to ensure that you have an advantage as a first runner. But then you must be careful that in choosing your trademark, you don't go choosing a generic trademark or a trademark that cannot stand. If you know that cellophane was once a trademark, kerosene was once a trademark, aspirin was once a trademark, escalator was once a trademark, and you know that Panadol almost went that way, but they had to keep saying, look, if it's not Panadol, it's not the same thing as Panadol. And you see the advert today about Indomie. Don't call everyone Indomie. If it's not Indomie, it's not Indomie. That's because people are beginning to call every noodle Indomie. So you must now be careful when you choose your trademark that it's not something that will become generic. On a few days ago, I was coming to Lagos, not this one, and I sat with a lady who is into fashion, and I asked her, okay, what's the name of your fashion, your brand? And she gave me a brand. Well, I won't call it here, but assuming she told me, oh, fashionable clothes. I was like, is that a trademark you want to use? She said, yeah, people love it. I said, no. They love it now, but it will soon die. Because you cannot use fashionable clothes as a trademark. I mean, every other clothes maker will call his or her own fashionable clothes. So pick a trademark that will be strong. Okay? Get a mark that you can build upon that would not be descriptive of what you are doing. So from the outset, the choice of your mark is important. From the outset, the way you do business is important. So ensure that you have clean, I don't know what you call it now. Well, your space must be clean. So for instance, if you are into leather and you just employed a young man to join you, and he's coming from another leather manufacturing company, he will likely bring in some know-how from that company. You wouldn't know when he will corrupt your system with that one. And then you will now be in infringement, not knowing that this guy is just using a design that he had taken from where he's coming from. So if you don't do the right background check, you end up with industrial designs that are not really unique or original to you. So you must ensure that you check on this. Maybe as we go on, we'll begin to look at the specific areas, what you should watch out for in the case of patents, in the case of industrial designs, and of course in this case of copyright. I'll leave it at that point for now.
Okay, so we'll go to, there's a lady over here.
Good afternoon. My name is Shade Thompson. My question goes to Ms. Oti. She mentioned something earlier about design protection strategy. I'd like to hear a little bit about that.
Okay, like in applying a design protection strategy, this usually starts from the creative process. A lot of designers abroad, like discussing with some lawyers abroad, what they usually apply is the look for advertising strategy. That's what they apply, like look for advertising. So when you see a Louis Vuitton bag, you're seeing the LV everywhere, right? That is a protection strategy. You see the Chanel mark on a product and all, that's a protection strategy. There is a particular place it has to be, not up, not down, it has to be in a particular place. So as a brand, it's essential that you work on a strategy. Like okay, for instance, if you're working with a trademark and you have like a particular trademark, maybe your logo or your company name, like either of them, you have to like have a strategy, because if you don't have a strategy, it would not be consistent.
Okay. All right, let's move on.
Does that answer? Yeah.
Okay, I think she... 1 second. Okay.
Well, I understand that part already, but in Nigeria, there are issues, especially if you can't have findings, metal findings that you can create that have your logo on them. How does one navigate that? And then you're not producing your own leather, so you can't maybe indent or create markings on them. So there's so many other things. I understand the need to put those markings on, all right? But how does one go from a situation where you don't have a manufacturer that you can go to and say, okay, can you create my logo in this metal piece?
Okay, it does not just have to be the logos. Like you can have designs also. You can work with like from the design laws, you can have like an aesthetic design, right? That you can actually protect. If you work with a design, okay, so there was this case, I can't really like remember the names, but it was a bag that had like artistic works on it, and the artist that designed the artistic work was not like did not give the bag creator permission to use the design, right? So in that case, there was an infringement. So like if you have that, right, if you have the designs, right, that is a means of protecting your work. Do you understand? So you don't have to like go to the manufacturer and say, oh, you have to like print my logo on this. So just think, be creative on how you want to protect your work, basically.
Okay, so there's something under the law that can allow me, okay, for instance, you know, with the Fendi bag, the rectangular one,
Right.
that rectangular shape is for that bag, all right? So if I create a specific shape, can I protect it under the law?
Okay, I think Mr. Hussain wanted to... Okay,
Yeah.
go ahead.
Well, let me start with the last question. Frankly, if it's about the shape, I'm not a lady, but I assume that there's a way bags have to look to be able to carry it around. So the functionality must not be what you're trying to protect. So if the shape of a bag is dictated by the functionality, then there's a problem. But you could go out of your way to do an, inverted bag, a bag that turns upside down. That would be innovative, okay? But having said that, in terms of strategy, there will always be a way out of things. If you don't make your leather, you don't make the metal parts and all that, you could sew something onto your bag. I mean, the Levi red label was not always on every jean, but over time, Levi got that. And in fact, they were so protective that anywhere they saw a tag on a jean, they will come after the person. If it's red, they'll come after you. If you had 3 stripes on your bag, trust me, Adidas will come after you. Now, that's part of strategy. You must be very vigilant. In protecting your works, don't let it go. If you excuse one, it becomes a practice. Then everyone does it, and by the time you're shouting, it's like, oh, it's everywhere, so why are you complaining? So if you have a particular design that you have come up with, make sure you police that, that design. So you must police as a matter of strategy. Like I said earlier, you must also be careful that you don't allow people to bring in to corrupt your production line. Okay? So if it's a label you want to attach to your product, it's protectable. In fact, the Trademark Marks Act defines a trademark as a label, a ticket, a whatever. So it's not just the name, it's not just the logo, it could also be that you tie it. In fact, you could choose that in your own case, you're not going to put your name on the bag. You have a tie-in, attachment to your bag. So anyone they see an attachment, that must be her product. So that could be a way of working around the problems.
Yes, and I have an example of what he just spoke about. I came with this.
I could help you if I would go with them after this. Wow, they're new.
Yes, when you see the red, true. What do you think? Louboutins?
Once you see these red soles, for those that know, women here, only one company comes to mind, right?
Yep.
Christian Louboutin. So he can make his shoe any shape, any whatever, but once you see this red sole, he has differentiated himself. I know there's quite a lot of litigation around it as to whether or not he can register this color as a trademark. I mean, when we talked about our trademark laws, we said that they're outdated. Our 1965 Trademark Act is a replica, word for word, of the UK 1935 Act or something like that. So, or 39 Act, so it's old. But this is one thing, you have to be innovative. Think outside the box. So you can't put your logo on the metal. You can use the label, like he said. You can color one part of it, and so on and so forth. But it's important in creating your brand to make it distinguishable from other people's own. It's very, very vital that when your customers see your brand, there's no question about it. They don't have to start wondering whether or not this is yours. The mark that you get, a trademark should be able to distinguish your goods and your services from those of other people in the marketplace. And like Mr. Sen said, it can be a logo only. So he mentioned the 3 stripes of Adidas, and I also came with this. Sometimes the name Adidas doesn't even appear. Just those lines are what they have, and you just know who owns it. But that has been created over time. When you start out creating your brand, you don't have that recognition or well-known status. You have to build that trust over time before you get to the point where you just do whoosh, and everybody knows that it's Nike, for example. I also came with, what else? Yes, Apple. So once you see this Apple sign now, Haba, you don't even need to. Do they even write Apple as Apple? It's not written, is it?
Nope.
It's just the Apple sign, and then you just know what it is. So in choosing a brand for your company or your business, you have to take into consideration things that are appealing to the eye, things that differentiate you, something that not everybody has, something that isn't in danger of becoming generic. Generic means that people now use it. Google it. Google is still fighting to make its name not generic. I say Google it, but I might use Safari, Firefox, or what's the other one as a search engine. But I say I want to Google it. It's wrong. It's a registered trademark of the company, Google Inc. So those are just some of the tips. And then on the issue of Mr. Sen also mentioned it, a staff moving over from another company. I think it's important that at the beginning you put structures in place in your business. Make your employees sign non-compete agreements, for example. Have terms of reference. Have terms and conditions. Protect yourself from the beginning. When you're doing the business, you may not have millions, but some of these things don't cost that much to put in place. Put structures in place. Believe that you're in it for the long haul, that you will get to the place where you don't have to write a name. You can just do the swoosh and people will get there. So if you start how you want to finish, you will do well. That's my honest belief.
Fantastic. All right, we're going to take more questions, but I'd like to know who's keeping time so you can let us know how we're doing. Please let me know. All right, we've got a question right at the back there. Thank you.
Hello, good afternoon. My name is Obiora. Sorry, right here. My question is like, okay, you've found someone has copied your design or your trademark or your logo. So what can you use to now defend yourself or try and rescue the trademark back? Or how can you, like somebody has copied your work, you've seen it, and then you want to now challenge the person maybe in court, or so what can you do, or what's the process like?
Is this on social media?
Social media or
generally?
Generally.
So I'll come from two angles, social media and like generally. So trademark, like all this, the intellectual property law basically caters for products that are in commercial use, basically. They're commercially used, or they have commercial value, rather. So like, for instance, okay, on the social media platforms, most of all these platforms, they have on their service agreements, they have stipulations that state what can happen when your rights are infringed upon, right? And like in that scenario, you can report misuse. That's for social media. But if someone is using your work on social media commercially, you can actually take legal actions. In that sense, you can actually get a lawyer, and your lawyer would actually check if there is an issue, if there's an infringement, and maybe a cease and desist letter will be sent to that party.
Okay.
Yes, and so you can take either administrative action or court action. Court action, there's a whole process called infringement, which Annie mentioned. You know, you have to have your own intellectual property must have been registered for you to go by infringement. So infringement is basically somebody is using a trademark so similar to yours that it causes confusion in the minds of the purchasing public. Or it can be that it's actually a counterfeit, that is, it's identical to yours, but obviously not the same as yours, or didn't come from you, in which case that is a counterfeit. So infringement, you must first of all have registered your own trademark. However, if there's a situation where you haven't registered your trademark, but you've been using it in the country and you can show evidence, or you have evidence, I don't mean legal evidence, but you can just show that I've been selling it, I have customers, I have my sales, all that, but you didn't register your own trademark. There's something called passing off. So the passing off basically means that someone else is using a mark similar to yours and you didn't authorize them to use it. So the standard that you have to prove in passing off is a bit more stringent. Whereas if you had registered it with the normal authority, government body, then all you have to do is to produce your registration certificate. But if you didn't register it, then you go by way of passing off, which is, most of Nigerian laws are based on the English common law. When Nigeria was what were we? A colonial, during the colonial times, so there's something called common law enshrined in all the Nigerian legal system. So where there's usually a lacuna in our statutory laws, we go to common law. So passing off is a common law remedy. So you can still eventually get someone to stop them from doing it. But of course, we all know the courts can take a long time. It's very expensive. The case can go on for a long time. But ultimately, our courts are aware of the intellectual property laws. And I think bodies like NCC and the Trademark Office, and which are intellectual property practitioners, we're trying to sensitize even the courts, the government agencies, on the importance of intellectual property and how it does need to be protected. I think this is a good time for you to tell us what NCC is doing about counterfeiting and all that. I'm sorry, I don't know.
It's okay. It's about you.
It's all right. Well, Okay, yes, as part of that, one of the problems we often encounter in this area is this: you be thief, I not be thief, you be rogue, I not be rogue. Is my own, is your own, I did it first, no, you did it first. And I think I missed answering a question that came from, I think from the rapper man or so, about how you prove that you own this particular work, The old method was, okay, do a registered mail, send the work to yourself, then don't open the mail, so just keep it. So if you have to go to court, you could show that this work existed at this particular time. Well, that's like old-fashioned, really. But if you want to choose that, you could just maybe do a courier to yourself and keep it somewhere. But more importantly is you should have records. If you're in this business, you should have records. So you want to do a new bag, a new design of your shoes, you do your sketch, keep the sketches. Apart from being of evidentiary value for IP purposes, it could fetch you money in future. You can imagine if I had the manuscript of Amos Tutuola, the Pawine Drinkard, or Chinua Achebe's first manuscript, handwritten, that would fetch money. Because when J.K. Rowling, became a success, the manuscripts alone fetched millions of pounds. So if you become a huge success tomorrow, and we can find the sketches you made when you were just coming up, that will be money. So keep your sketches. And when you go to court, and you need to prove who did what first, that will be very helpful. So your sketches, dated, will always help improving. Now, coming to the registration issue, from the copyright angle, what we have introduced is a registration system now, which is voluntary, that allows you to, do e-registration of any artistic work. And the commission will have custody of that deposited sketch or picture or whatever it is. So it stands as an artistic work. It's important because there's this problem, this gap in the fashion industry where they say, well, we will not protect the functionality of, the fashion design, but we'll protect the artistic work embedded on it. So while we'll protect the print as it is, we may not protect the way you sew it because we think that that's, a functional thing. So there's that huge debate. But I know that when Ben Enwonwu, late Professor Ben Enwonwu, brought an action against Nitel for Nitel's use of the drummer on their logo. Nitel's argument was that, yes, the drummer is in public place, therefore it's not protected by copyright, which is true. But that's one of the exceptions, that any work in public display can be reproduced without recourse to the owner. But what Ben Enwonwu did was to show the original sketch of the drummer. I said, no, I'm not talking about the sculpture. I'm talking about the drawing, which is the sketch. And that, Nitel had no response to that. So in some cases, you may not be able to sue for the infringement of the dress you have made, but you may want to say, okay, there's an artistic work that you are concerned about, and that is the drawing. And the drawing now is being taken to a 3D from a 2D, and that could give you a leeway. So I believe there are multiple ways of catching a bird. So the first thing is make sure that you have a registration. It's always better. If you want to use passing off, that's when you don't have a registration, like my colleague said. So have a registration, whether it's copyright, whether it's trademark, have it. But don't be your own enemy. Sometimes it's the way the dealings that kills, the legal right we should have had. When she mentioned that you should not, you should make sure that you place the logo properly and all that, it's very important because the integrity, the worth of your mark, it depends on how you yourself use, that mark. So you must make sure you know your own worst enemy by 1, not registering, 2, using it carelessly, 3, giving it to just any person without a contract, and not having proper dealings when you want to license. A friend comes and says, oh, I like this your thing, they say, but well, if you use them, one friend uses it today, that friend gives to another friend to use, and it goes on and on. Make sure you have your boundaries well set. You can't use it. If you must use it, this is how you will use it. Be strict about that. And before you know it, your brand will begin to grow. I don't think there's never free lunch. Oh, we just want to promote you. There's nothing like that. I mean, for that promotion, get the value out of it. So don't just let anyone pick your product and say, we'll promote you, let's just use it, and it goes that way. Then they cut off your credit when it's used. Before you know it, you've lost it. So you must keep those boundaries and be your own first watchdog.
Absolutely. Creatives hear that all the time. Exposure. We'll give you exposure, for whatever. So you wanted to say something?
Yes. When he was talking, something came to mind, which is about leveraging IP assets, how you can use a brand you've created and leverage it to make more money for you. So that's basically things like franchising. So for example, you own a brand, you make leather goods, you want to start selling it maybe outside Nigeria, but you don't have the resources to go to Ghana or go to, some other African country or the UK or America. So you look for someone who is in that line of business, who doesn't mind taking your brand there, opening a shop along the lines of what you have here. So that just had me thinking. So things like licensing your brand out to other people. Sometimes intellectual property allows you, the owner, to give permission to a third party to use that mark, and they pay you what we call royalties. So that is another way you can also make money out of a brand you've created. So each time that item is sold anywhere in the world, you get something back. For instance, the Benewangu he mentioned, or even Chinua Achebe, the books are sold worldwide. The royalties perhaps go to the family. It is something that inures time. The things you use your intellect to create are things that, they're so special. I truly believe in intellectual property, that it's the future of any nation. Things can die, but the power of the intellect never dies. There's always a way you can create things that can make you more money, but you have to think about protecting it.
Okay, also about licensing, it's also very important as people that have brands to work with contracts. Mr. Essien mentioned something about contracts. It's really important because you protect yourself from liabilities. So if you're licensing your design or something, you need to work with agreements. If you're employing someone and you want to have trade secrets, or you have trade secrets in your company, work with non-disclosure agreements. With your employees, have employment agreements, because they would really help you. They will provide clarity for you.
All right. I think we can take one last question. Oof. Okay, let's take... Okay, I have to go. Let's take two real quickly. We have to answer real quickly. Can we bring the microphone? Okay, let's take her first. So two last questions and we've got to go.
All right, good afternoon. My name is Vivian. I'm a model. Please, my question is for Chinyere. Please, I want to know, does this intellectual property, does it protect those of us in the modeling industry? Like, let's take, for instance, someone uses my picture without my consent. Does the law protect us as well? Because, for example, I'm not registered with any agency. I'm just a freelance model. And someone uses my picture without my consent. Who do I cry to in that situation? Thank you.
Please don't cry. In this field, there are always good stories and bad stories. The law does not have answers to every question. Unfortunately, models are not protected in that manner. For instance, the copyright system will protect the photograph and will give the right to the photographer. The model is not covered by copyright. So that your face is in the photograph is not a copyright issue. It could be an image right issue. So when your image is used commercially, for instance, you could sue in the general law, not copyright. At the same time, when you're having dealings with a studio and they're doing a shoot, it behoves you to ensure that there's an agreement and there are clear covenants as to what they can do and what they cannot do. Otherwise, they will take your photos and then begin to trade in those photos. So ensure that you protect from that point on, and when they commercialize, you can then bring an action. Someday we'll probably have a law to protect models. Thank you.
Okay. Okay, can we take the last question real quickly? We've got to wrap up. Thank you. Okay.
Hello, good afternoon, everybody. My name is Eniye Ogwebo, and my question is for Mr. John Assign. Okay, thank you very much for being here. I mean, your contribution has been invaluable. But my question is not specifically as regards copyright. I'm just saying intellectual property in general. How have we, I mean, from the government's perspective, been able to position Nigeria, market brand Nigeria, vis-a-vis geographical indications, appellations of origin? I'll give you a typical example. You cannot sell cheese as feta cheese if it's not from Greece. You cannot sell sparkling wine and name it champagne if it's not from the region of Champagne in France. So in Nigeria, I believe there are lots of things we have that are unique and generic to us. Adire, for example, I'm talking specifically, I'm going to limit it to the fashion or creative space now, to say from the government side, how have we been able to market these things, to say these are unique to Nigeria, so that if anybody else is, no, I don't want to use the word appropriating, using it, there is some sort of commercial transaction in the process, if it's a licensing agreement or whatever. I mean, maybe I should not expect. Yeah, I'll leave it to you now to.
Thank you. You should have answered the question really, and thanks for that. I mean, it's very enlightening. Now, again, that's a gap. Nigeria does not have a sui generis protective regime for GIs, but then we have a trademark law that provides for certification marks, for instance. And I'll argue that, yes, we don't have GI provisions, but we can use that to protect our GIs. For instance, I don't see why Ofada or the Ogun State government cannot go to the trademarks office and register Ofada for rice, and then go back and certify every Ofada rice farmer and allow them bag the rice Ofada, and then go after anyone that calls his rice Ofada. I mean, India did that with Basmati, and they fought to the highest court in the US to get Basmati out from the protective regime. Because for IP, you could either use the proactive one, or you could use a defensive mechanism to ensure that you still hold your rights. Now, talking about the fashion industry is also very instructive, because a lot of out there today, people are looking for the motifs that represent, like Africa, for instance. But we have to find a way of identifying those ones. And we must consciously put a stamp on those ones and sell them as authentic Nigerian designs. It's a pity that Ghana has been able to do a few things with its kente, right? But in Nigeria, Adire is just Adire. So we will do more. And I think that's where we all must come together. Industry must talk to government, must talk to the experts. Then we find solutions customized for that industry. I think it is doable, and if we are serious about it, we should be able to regain. Having said that, there's also the risk of the producers themselves thinking that some motifs are just out there, so they can pick that. And so when you see people picking street designs, street art, putting it on the fabric, there's been a lot of, controversy over that. Because the fact that it's on the street does not mean it is free. So I think as we wrap up, I'm sure we'll be able to have that dialogue between industry and government. Then those people in the government will find the solutions around the laws to help the industry grow in that wise.
I'll just like to add a little bit. What a lot of countries have is what is called an IP policy. So an IP policy is basically the government's response to how intellectual property is treated, how it's identified, how it's protected, how it is leveraged, and how you can deal with any cases where there's a conflict. Nigeria doesn't have an IP policy. And it's something that I know the Copyright Commission, the Industrial Property Regulatory Body, and lawyers in the private sector and stakeholders, we're having these discussions now about how we can help Nigeria develop an intellectual property policy that will be binding on all of us. And definitely things like this, Ijebu Gari, for example, will be part of the discussion. The GIs he mentioned are geographical indications, which are basically like the Scotch whiskey and the champagne you mentioned, things that originate from a particular region or geographical country or place, which are peculiar to that area. And so for you to put that label on the item, it must have originated from there. And they have laws protecting it. So these are the discussions we're having now surrounding intellectual property. The government and the private sector have to work. We can't leave it for the government alone, that's the truth. We as stakeholders have to push it. Government agencies are limited in what they can do. And I always say that if it's not about oil, the government isn't always listening, right? And we don't have money like the musicians and actors like Nollywood and co. So sometimes those other areas of intellectual property get left behind or don't form part of the conversation. But we are pushing and we're hoping that things will get better in the future.
Thank you so much. I wish we could go on, but we've got to prepare for the next conversation, which is going to be about money. We're going to be talking about talking money, understanding your numbers to access capital. And on that panel, we have Adenike Adeyemi, Executive Director, Fate Foundation, and Olutosin Oni, Principal, Investments, Echo VC Partners, LLC. But at this point, I'd like you to put your hands together for Chinyere Okorocha, for Annie Oti, and John Aseng for doing such a fantastic job. This conversation has been elevating, informative, and just wonderful. So thank you so much for coming. We appreciate it. Have a lovely day. So the next conversation will start in about maybe 45 minutes or so. So please go around, see some more stuff out there, and then please let's come back here to continue the conversation. Thank you very much.